talk about software patents and whether they are good, whether we want them, whether they're possible here, all of those different topics. So, first of all, we will have a more in-depth discussion of what is a patent from the Patent Office, but before I get to the meat of my presentation, I should just explain what is a patent. A lot of times you'll read in the newspaper that someone has patented something and they mean trademarked, or they trademarked and they mean patented, or they copyrighted and they mean neither, any of those. So these three word terms are used interchangeably, and they should not be. They're very, very distinct rights, and they protect very different things, usually. So patents protect inventions, which means things that are industrially useful and are novel. And there are other requirements, but those are really the key things. So something that has never been seen before, and something that is useful. Copyrights protect something that is artistic, but not usually useful. Trademarks protect logos and those sort of things. All of this will be described in great detail, but for now I think that's, I just want to give a small background. So a patent is a government-issued right to exclude others. If I get a patent on an invention, say a computer, which is useful and say it has never been seen before, then I can stop everyone else in the country, this country, from making the same computer. It's a limited right, so the term is usually 17 to 20 years. And then after that time, anybody can make the same computer without having to license the technology from me, without having to worry about me. And it's limited also in geography, so it's a patent issued in one country is not generally recognized anywhere else. Why do the governments issue these rights? Well, there are many reasons, but usually it's to encourage full disclosure of what it is you're doing. So if I've patented the computer, I have to tell everybody, in order to get that patent, I have to tell everybody how I made the computer. What was the process for making it? How do you use it? All of the different background things that would help someone who's as skilled as I am to make the same thing. So that, therefore, at the end of 17 or 20 years, or whatever the patent term is, everybody who has the same level of skill as I would be able to make a computer. And therefore, theoretically, patents encourage not only innovation, but also encourage distribution of information. Copyright's very different. Protecting artistic works, much longer term, and so usually the life of the author plus 50 to 70 years, much longer than the 17 to 20 years, and you don't need to have anything useful to copyright. It doesn't need to be useful, but it does need to be fixed. It needs to be written down or in some way tangible. So in patents, people ask, can I patent an idea? Well, if you fully describe the idea, and you don't actually have to make what it is you're patenting and show the patent office, look, I have this computer, I want to patent. They won't ask to see it, but you have to describe it in such a way that people could make it. So with copyrights, it actually has to be physically written down. With patents, not so much. Well, it has to be written down only in as much as you're submitting the application to the patent office. So software patents are patents that cover inventions that are executed using software. And I'll give examples of this. They're allowed in the US and in Europe and elsewhere in various forms of one or another. And the question today is, are they allowed here, and should they be allowed here? So, okay, I'm breaking the first rule of presentations. I have lots and lots of words on the slide. Don't be intimidated by this. This is, okay, actually before you even start reading it, a patent consists of what are called claims. The patent can be a long document, hundreds of pages long, but really all that matters is the claim at the end of the patent, and the claim tells everybody in the world what it is you're patenting. In one sentence, the claim describes your invention. In one sentence. It has to be one sentence. So I'm going to show you a claim from a software patent from the United States. I'll give you a minute to read it. And I want you to tell me who owns the patent. And if you know, because you know me or whatever, don't yell it out. But if you've never seen this before, try and guess who this patent belongs to. Say it louder. Facebook. This is the patent that covers the news feed that everybody uses on Facebook. So this is how patent lawyers describe the news feed. There are many things I could say about this. One is, the ordinary person on the street, whether they're in Kenya, the United States, or anywhere else, would have no clue what this means in general. I mean, you know it because you've seen Facebook. Everyone can appreciate this because they've seen the product itself. But to reproduce the Facebook newsfeed like this really takes a skilled lawyer. And sometimes I think that lawyers developed this system so that people would have to come to us to do this. It's a brilliant way of making money, actually, but whether it's good for the industry, we'll decide over the next 2 days. But anyway, so this is what a software patent kind of looks like in the U.S. at least. This is what Facebook filed for and got. It was issued late last year, I believe. And so now, anybody in the United States cannot, well, nobody in the United States can do what is described here, theoretically. Of course, some people will and do, and Facebook has the right to sue them. I'll give you one more example. So again, I'll give you a minute to read this, and you tell me who owns this patent. Yes, I heard it. It's just prominently displayed right over here. This is the Google patent that covers their PageRank algorithm from 2003, I believe. Google patented the method for, well, this method here, which is basically the Google method. So now, when this patent expires, everybody will be able to look at the patent and theoretically see what it is Google does and reprogram in the exact same way, or close enough that it does the same thing, theoretically. But this, I mean, I would call this perhaps one of the most valuable patents ever. Google is certainly one of the largest companies ever, if not the, at some point, largest company. And it's really built on just a few patents. So this is another example of a software patent in the US, and nobody in the US can do what is listed here without running the risk of infringing Google's patent. So who has Google patents? Well, obviously Google and Facebook. Google has over 1,500 issued patents. In fact, more than that now, but I've calculated the costs here. So the costs are something you should keep in mind when we're talking about this. One of the arguments that you'll hear is that they're expensive. Well, that's very true. So a patent in the United States costs over the life of the patent, and then by the life of the patent I mean the 17 to 20 years. In filing fees and registration fees and just fees alone, no, I'm not talking about lawyer fees or lawyer costs or personnel or anything like that. It costs about $12,000 to keep a patent in force with the patent office over the life of the patent. So the Google's 1,500 or so patents cost them $18 million. Obviously, those are pretty useful patents to Google, so they're happy to spend that money. Facebook also now has about 30 issued patents, and they're getting more every day. Well, not every day, but over time. IBM, far and away the largest patenter for many years, and they have 73,000 issued patents, but I only know that as of 1976 because the records that I was looking at don't go before that. If you calculate $12,000 per patent, that's almost $1 billion in patent fees. That is not counting any attorney costs, and I guarantee you the attorney costs are usually more than the fees. I know that for a fact. So $1 billion over, how many years is that? Not quite 30. Well, over 30, now 35, 36. That's some significant investment. And obviously IBM has a lot of non-software patents. It's hard to say how many of them are software and how many of them are hardware, but patents are really a big deal around the world, and particularly in the United States. There are over 8 million issued U.S. patents now, something like 8,200,000 or 300,000. And the rate of increase is really astounding. We reached the 8 million point less than 2 years ago, and already we're well over 8,200,000. So patents issue at an enormous rate in the U.S. Slower in Europe, slower in Japan, much slower in certain other countries, but still very many. So let's put this into a Kenyan context. The Kenyan law before 2001, and if you're not a lawyer, then I'll explain this in non-legal terms, basically said you could not patent software, period. And it says right on the law, the highlighted words, you cannot, it's excluded, regarded as inventions, not regarded as inventions, for the purpose of patent protection, computer programs. In 2001, Kenya changed the law, like many developing countries, in order to be compliant with TRIPS, which will be described to you later. But it's an international treaty that is somewhat controversial, and in any case, pretty much all developing countries have been or have changed their law. Kenya also did, so the 2001 Industrial Property Act was changed, and here it is, the relevant parts. And as you'll notice, something strange was left out of the law. It doesn't say computer patent software. So now, but I've highlighted methods for doing business. As you'll recall, that was also excluded from pre-2001. But it's kind of and there are people looking into why, but I won't say why, I don't know why, but it was explicitly left off of the list of things that are not excluded. So that means that the law does not say you cannot patent computer software. So let's say you apply to CIPI, the Kenyan Industrial Property Institute, for a patent that covers software or computer software. Let's say you even apply with the exact same claims that Google or Facebook have applied. What will CIPI do? Well, they have several options. One of them is to reject it outright and say it's a business method. If you look at this and you think about it, I could easily make the argument that this is a business method, right? On the other hand, being a lawyer, I'm very good at coming up with arguments why this is not a business method. So CIPI has the option of just saying, no, all software is a business method. Whether that would stand up in courts, I have no idea. Whether that would be, what would the outcome of that be, I have no idea. But they could do it, for sure. There are very good arguments to say that software is a business method. And in fact, in the US, business methods are explicitly included in, well, not explicitly, but they are included in patentability. And so that's not an option in the US, but a lot of people say software are business methods. CIPI could also decide that no software is a business method. And I'm pretty confident that given any software claims, I could probably come up with an argument that it's not a business method. So CIPI could decide not to allow, assuming that it's a patentable invention, all software, computer software patents. And the requirements for patentability will be presented to you. And that actually is sort of a key thing, because it's very difficult sometimes for software to be considered patentable. Anyway, so the third option is to amend the regulations. The Industrial Property Act is guided by regulations that CIPI makes, or CIPI and other stakeholders make to help them execute the law. CIPI could say in the regulations with an amendment that business methods or software is defined as a business method. Or of course, we, Kenyans, could amend the law and say no software patents. Or we could say all software patents are not business methods. We have a lot of options here at this point, and basically any of them go, really. So I think that this is really the critical time, given the importance of the ICT industry, which you'll hear about from Mugu Kibati, from the PS, from a lot of people, which you already know, we're preaching to the choir. But in any case, given the importance of it, do we want to go down the path that the US has gone down? Do we want to go down the path that Europe has gone down? Do we want to, well, we will explain to you what that means over the next 2 days, so we can decide. We, as in Kenyans in general, can decide, how do we want CIPI to approach these inventions? Do we want patents on software? So really, I think it's up to Kenyans at this point to tell CIPI, and CIPI is here, by the way, and listening, and want to hear your opinions, so we will have a lot of question and answer time, and time for you to voice your opinions. But in general, you can always say to CIPI independently, if you're not in this forum, this is what we want. They have they have kind of, I'd like to say they have sort of free reign at this point to deal with this as they like. But I think it should be best. I mean, there's no case law. There are no court cases that I'm aware of that describe any of this, and it's really up to us at this point to decide. So that is my presentation for the background in software patents.